welcome everybody to the webinar tonight, and our topic is Who Decides What and Other Touchy Topics. My name is Janet McLean, and I work with Family Caregivers of BC, and I will be introducing our guest presenter, Joan Braun. Just a couple of slides to get us started. Family Caregivers of BC is 100% dedicated to the well-being and support of family caregivers. We are a nonprofit and have been in existence for 28 years in Canada. We were the first of our kind, and we've been serving all of BC since 2010, and the past 5 years as part of the Ministry of Health Patients as Partners initiative. So we're really thrilled to be able to provide a provincial program, and the ministry funding allows us to do these webinars, which is just terrific. We do a whole variety of things, and this is a bit of a busy slide, but we have three main pillars in the work that we do. We have caregiver support, education, and then collaboration and engagement. In terms of caregiver support, we have a toll-free line. Our website has all kinds of resources on it. We have support groups. We help establish support groups across the province, and we have resources on our website that you can check out. In terms of education, we do webinars like tonight. This is being recorded. We have recorded webinars you can view on our website. We have a newsletter and all kinds of ways for you to keep abreast of caregiver news that might be of interest to you. And last but not least, we are collaborating with the health system to improve health planning and delivery. And so we engage caregivers to be a voice at tables across the province. And if anyone is interested in that, there's a spot on our website to indicate that you might be interested, and we'd be thrilled to bring you into our program. But it does apply to you. We are just thrilled to have our presenter today, Joan Braun, and Joan is in private practice as a mediator, but has a fascinating background as a lawyer, and she worked for years in social work and law before entering and becoming a lawyer, and also has lots of experience in terms of nonprofits. She worked in the nonprofit sector for years and was the executive director and supervising lawyer for the BC Centre for Elder Advocacy and Support. So Joan brings lots of experience and knowledge to the webinar. We're really lucky to have someone with her with that background, and again, I would really encourage you to ask questions. I know that she's got her own examples, but the experience will be much richer if you have some things to ask. So Joan, thank you so much for joining us tonight for this webinar. And what I'm going to do now is change the screen again, and Joan will begin her presentation. And just before you do that, Joan, I'll just give people a short orientation to the screen. So as I've mentioned, on the far bottom left is the chat screen, and I would encourage you to type into that chat screen any questions that you might have or any comments. The main screen that you can see is Joan's presentation, and just below that, we have uploaded a PDF of Joan's presentation, so you don't need to be wildly taking notes. You can download that presentation now, or you can wait until the recorded webinar is on our website, and we will also have the PowerPoint PDF available. So Joan, thank you so much, and you can take it away.
Great. Well, thank you very much for inviting me to present today. It's always exciting and a pleasure to speak on this topic, and perhaps I'll just mention a little bit more about me, and also since this is a webinar co-sponsored by Mediate BC, I'll mention Mediate BC as well. As Janet mentioned, my background is social work and law, and I was in the social work field before going to law school, and I went to law school because I had two different interests. One of them, I was very interested in continuing the advocacy work I'd done, but from a more legal perspective. And I had also taken some courses in mediation, which I enjoyed very much, and I thought that a legal background would help me with that. And actually, since attending law school, I've actually carried on both of those interests. I ended up working in the field of law, focusing on areas particularly dealing with vulnerable clients and doing advocacy work, and also have worked as a mediator in private practice. And it's in the latter capacity that my relationship with Mediate BC came about. I've been involved with Mediate BC as one of the mediators on one of their rosters for several years, did mediation at the Small Claims Court, which was a project that they operated. And so when they approached me about doing this webinar in conjunction with the family caregivers, I was thrilled to do that. And just let me add one more thing before I get going on this topic. As Janet mentioned, I am the former executive director of the BC Centre for Elder Advocacy and Support, now called Seniors First. And I had the privilege of working there for about a 4.5-year period when we established a legal aid clinic for older adults here in British Columbia. And that is actually when I developed this interest in using mediation to resolve family conflicts, because we had a toll-free telephone number there that was a helpline for seniors. And what I found was that we received many, many calls actually from family members who were concerned because their parent was aging, there was a conflict in the family about care issues and so on. And with my mediation background, I started to think maybe mediation could be used to resolve some of these issues. I looked into it more and discovered that mediation is used quite commonly to resolve elder issues in the States and has been for quite some time, but is a newer field in Canada. And I'll talk a little bit about that as we get going.
Joan, we just have one comment in the chat box that Maureen is wondering. So I don't know how you can do that, because I see you've got your cell phone headset in, but maybe just if there's a way of bringing that microphone. Oh, perfect. I think that's going to help.
Yep, we're trying this. Does that help, Maureen? Maybe you could type, bring that closer. Is that helping at all? If not, I may have to take off the headset and put the phone to my ear, but is that better?
I can see she's typing in right now.
Okay, well, we'll continue this for a moment, and if I hear it's not better, I'll pick my phone up to my ear and we'll go from there.
She said it started to, but now it's even fainter. I'm wondering about other folks if they're having difficulty. We've got a couple of other folks typing in right now. It's hard. It's always hard to know if it's just one person and their system or whether it's, what we're doing. So, okay, others are saying it's okay. So, I don't know, Maureen, if there's a way for you to turn up your volume or.
Yeah, because my mic is quite close now. It's right there. So.
Okay. Well, I think we'll just assume that we can keep going.
Okay. All right. And by the way, I'll try to keep a better observation. Thanks for letting me know about that, Janet. Just anytime I'm missing something in the box, let me know.
Okay.
This is actually, I've given presentations many times, but this is the first time I've given a presentation in Adobe Connect. So if I miss something, then just let me know, and I'm happy to hear.
For sure. Thanks, Joan.
So this is the introduction to my presentation today. Essentially, there are two objectives for this presentation. And the first is to learn how mediation can be used to resolve family disputes over caregiving issues, and then also to learn about relevant laws and where relevant legal options exist. And I've essentially divided the time into two sections. As Janet said, if there are questions along the way, we can stop, but I've also built in a question period at the end of the first objective after I talk about mediation and give you a bit of an overview of that field. So essentially the outline, I'm going to talk about family conflict over caregiving, what is elder mediation, how to choose an elder mediator, and then I'm going to move into the legal aspects of talking particularly about capacity and abuse and what some of the relevant laws are. So when we talk about elder care disputes, the word is commonly used, as I said, especially this is a growing field in the United States, and the term commonly is elder mediation. Well, that is a very broad topic and can relate to any conflict involving an older adult. But here specifically, we're going to talk about conflict over issues that have to do with care of an older adult. And this may be a situation where there are significant healthcare needs, or it may be a situation where there's perceived needs in the future and there's already conflict between adult siblings about how to deal with those issues. So the conflict could be among the extended family, or it could be between mom and dad and the family caregivers. Either way, mediation is something that can be one option for resolving this. So examples of specific issues that could be in conflict, issues over who should pay bills that are coming up, where the older parent should live, whether an admission to long-term care is appropriate, how family members should divide caregiving responsibilities, perhaps safety issues. Perhaps mom or dad is living in a situation that other family members don't feel is safe, health or personal care arrangements, etc. So one of the values of mediation, and I'll give you an overview of what mediation is and how it applies to this field in a second, is that it's a process that can allow all family members to reach agreement in a way that preserves relationships in the family. For example, supposing there's a situation where an older parent very much wants to maintain independence and the adult children want the parent to be safe and don't perceive that the older adult's choice is keeping them in a safe situation. And so different family members may have a different beliefs about what's safe in that situation and what independence is. Well, mediation is a process in which families can talk about values and about what's important and then reach a resolution or create a plan that best fits everybody's values and everybody's needs in that situation. So how do these situations arise that end up in mediation? Well, one leader in the field talks about how conflicts in families often arise at a point of transition or a point of change. Maybe there has been a death in the family. Perhaps a family member has had a change in circumstances, a change in health, and as that person goes through change, it impacts the entire family who is adjusting to the change. And the leader that I was speaking of, her name is Nancy Solnick, and her comment is that loss, stress, and change in circumstances as we age may be the true axis around which these conflicts that come to mediation turn. And one of the things about mediation, because mediation is a process in which family members, in this case, sit down with a neutral party who helps the family talk through what the options are. And by family, depending on the situation, this could be the adult siblings or the extended family. It could involve mom and dad and the extended family. It would vary from the situation. But where those who are in conflict or are wanting a solution sit down together and talk about it, the mediator is a neutral party to help the family create a plan or a solution to the issue that's in conflict. And often when there's conflicts, it may be about a particular issue. I mentioned how I first started thinking about using mediation to resolve these issues when I worked at the BC Centre for Elder Advocacy and Support, and we would have many calls per month from families, and often it would, say, be an adult daughter who would call and say, I'm very concerned about my mom. She's living with my brother, and I don't agree with how he's providing her support and care. And then we'd have a call from, I think sometimes it could even be someone from the same family, but it might be from another family saying, you know, I'm really worried because I feel like my mom needs extra services and she doesn't want to have those services at this time, and I'm not sure what to do. So these kind of calls were coming to our toll-free line all the time, and we didn't provide services to families, just to the seniors. So as I said, that's when I started thinking about mediation. Well, one of the values of mediation is that it gives an opportunity to talk about what some of the underlying values are and to come up with a solution that fits with the underlying values. It could be a situation where, say, there are several adult family members who are caregivers, but one family member is doing a lot more of the care out of a sense of duty. It could be that a decision needs to be made, but the best decision in that situation, one particular family member is not comfortable with because it has a symbolism. Perhaps it might be best for mom or dad to make a move, for example, and live somewhere else, but that has a symbolic impact on someone where they strongly believe, say that mom or dad should stay at home, or mom or dad believe that they should stay there. So there's some type of symbolism that makes it difficult to look at different issues. And of course, different people in families play different roles. So that can also come into play when there's a conflict. So let me give you two examples just very quickly of when this may come up. Take, for example, the Green family. And one day, Mrs. Green is talking to a close friend of hers, and her close friend of hers talks about how upset she is because her children are worrying too much and are now starting to fight about what type of care to provide or what type of support to provide. And Mrs. Green comes home and talks about how worried or concerned she is about what's happening in her friend's family, and says, you know, I wish there was a way that we together could talk as a family and plan ahead for the future. You know, what if things change in our lives, and I really wouldn't want to be a burden on you children. And well, mediation is something that the family could participate in proactively, where a mediator helped them to create a plan for the future. Contrast with a situation like the McDougall family, where dad has suddenly, he's been living at home for many years, he's suddenly had a fall and has serious care issues, both physical and cognitive, and family members cannot agree on how to deal with the situation. Unfortunately, a plan was not in place, and now there are 3 adult children, and the adult children are in conflict about what next steps should be taken and what's the best way to take care of Mr. McDougall. Well, again, that's a situation where perhaps if Mr. McDougall had very limited cognitive ability, he wouldn't participate in the mediation, but the adult children could join in together and could talk about what's the best way to deal with the particular situation. And mediation can prevent possible consequences of not resolving the issue, such as stress on the family and, you know, potentially a risk to the older adult, or an estrangement of one of the adult children who doesn't feel comfortable with decisions that are being made. So elder mediation provides an opportunity to resolve disputes in an amicable way that maintains relationships. I mentioned earlier that elder mediation is much more common in the United States than in Canada. There's a wide range of disputes that mediators are involved in resolving, both lawyers and non-lawyers. In Canada, the elder mediation is a much smaller field. It's just beginning and just starting to grow. More typically, in Canada, a lot of mediators who work in the elder area are lawyers and focus on guardianship issues or wills and estates, but I believe that the field has great potential, and there are now an increasing number of people moving into the field. We can talk a little bit in a moment, or I will talk a little bit in a moment, about how to choose an elder mediator, because even in the past 5 years, I've seen tremendous growth in this area, and more qualified people, mediators, gaining the expertise to work with older adult issues. So mediation is a process in which a neutral third party acts as a facilitator to help the parties resolve a dispute. Elder mediation refers to mediation where one of the parties is older or the dispute is one that predominantly affects older adults. So how does the process work? Well, typically, someone will call a mediator and will say, our family can't agree on an elder care issue. I'm wondering if mediation would be an option. The elder mediator will talk to that person, will ask them who else is in the family and who else needs to be part of the decision-making process. And mediators often then, with the permission of the person that called, will call other family members to see if they're willing to participate and to explain what mediation is. Once there's an agreement to participate, the mediator would get the family to sign an agreement together, not resolving the dispute, but an agreement about how the mediation process will work. And many mediators will then speak alone to each of the person who's going to be part of the joint conversation. And at the joint conversation, the family will talk together about how to create a plan. But many mediators first speak to the participants alone. Some of the things that are resolved at that stage is figuring out what family members will be part. Typically, if you want family members to be part of the caregiving going forward, then you'd want them to be part of the decision-making or the mediation process so they can be involved in making a plan. But it's very common to also include other support persons or friends there as well if they're going to help the process, or even outside caregivers who know the older adult very well. At that early stage, it's determined what the goal of mediation is going to be. And then after the mediators met with everyone alone, there will typically be a joint meeting where everyone attends, an agenda is created, and the family begins to work through the agenda with the help of the mediator, acting basically as a navigator and helping the conversation and redirecting onto topics that will be helpful, and helping the family identify what common interests are, to brainstorm options, to choose solutions, and then together a plan is created, and typically mediators will write up the plan in a memorandum of understanding so everyone knows what is agreed on. And the issue at conflict could be as simple as, bills are needed to provide care and mom or dad doesn't have enough money and the adult children are willing to split the cost, but they haven't agreed on how. That would be a very simple dispute to resolve and wouldn't take that long. On the other hand, it could be a very complex situation in which basically a plan is needed as far as where mom will live, who will provide care, and all kinds of little details, and that would take much longer to work out and to resolve and to set out. So a mediator is not resolved in the dispute, does not have an interest in the outcome. He or she is neutral. The agreement is reached among the participants. And as I mentioned earlier in the two illustrations, it can be used preventatively, sort of as a family planning tool. It can also be used to resolve a conflict once it has arisen. And there has some interesting research done years ago by a scholar named Yvonne Craig, who actually found that mediation preventively can help to prevent elder abuse. So by a family meeting together, if there's a concern about the safety of the elder, mediation that happens early could prevent a situation later where the older adult may be at risk of harm. So elder mediation is used in a variety of different situations, not so much in Canada, but in the United States. In many jurisdictions, there are elder mediation programs based out of the courts, particularly if the family is having a conflict about whether the older adult is capable of managing his or her own finances and affairs. It's very common in many American states to have a program to resolve that at the courthouse. Alternatively, mediation could occur in private practice. That would be more common in Canada, where families hire a mediator to help the family find a solution. And lastly, a care home or a assisted living facility may hire a mediator to resolve conflict between residents or between family members in the care home. So it could be used in a variety of different locations. In British Columbia, elder mediation is a new field. It's available through mediators in private practice. And I'd suggest for anyone interested in mediation that it's very important to choose a mediator with relevant experience. And what I'd offer about of that is if you're thinking of hiring a mediator, research the mediator and his or her background. And if I think it's important, or there was some research done that looked at what type of training makes a best elder mediator, or what basic competencies are needed. And you'd want to hire somebody who has solid mediation training. Here in British Columbia, many mediators who have a certain level of qualification are on Mediate BC's roster. So that would be a good place to start. You can Google Mediate BC and roster, and you'll find a list of mediators and a description of their training and credentials. And all those mediators have a basic level of training, which is pretty solid and experienced. In addition to that, it's important that the mediator have an understanding of those specialized issues that might arise in this area of practice. So if, say, a mediator is a lawyer and is newly getting into the older adult area, have some training on issues of aging and care issues. If a mediator comes from a background that where they would have solid experience working with older adults in the aging field, then it would be important to add training about some of the laws that arise in this area, about powers of attorney and substitute decision making and so on. And I've listed 4 different areas where it would be helpful to have training in mediation, elder mediation, to launch into this field. There are some specialized elder mediation training programs, but those aren't as common here in Canada, so you wouldn't necessarily find a mediator to have that. So I would suggest looking for someone, as I said, who has mediation credentials as a generalist and who also has training and experience working specifically with elder care conflicts. And I've done quite a bit of talking here, and I've discovered it's impossible for me to actually read questions and to talk at the same time. So I'm thinking, first of all, Janet, let you pop in any questions that I should attend to first, and then maybe open things open for discussion and more questions. Sure.
Sounds good. Well, that was very informative, and we do have, when you were going through the examples that you provided, Joan, one of the participants typed in, or if mom/dad has lots of money and refuse to spend any of it on their own care.
Right.
So I don't know if you have any general comments about mediation in those types of situations. You gave an example where the family was kind of coming to an agreement about how they were going to split the financial responsibility.
Right. Yeah. Well, so one of the things that I think is great about mediation is these situations can be very difficult because people can have very divergent needs. I actually was my mother's caregiver towards the end of her life, and my mother had very strong opinions about what services she wanted and didn't want. She didn't have lots of money, but I'm quite sure if she did, she wouldn't have wanted to spend it. So I can kind of relate to that. I have no question about that at all. One of the things, regardless of what the specific issue and dispute is that one of the advantages of mediation is it gives a chance to talk about what some of those underlying values and reasons are. So in mediation, you wouldn't be limiting the conversation to just the question of, I don't want to spend money, you need to spend money. And those are essentially the positions or kind of what the surface issue is. Not that in any way to diminish that those aren't important. They really are. But the advantage of having a mediator involved is the mediator could, for example, in that scenario just described, meet with the parent alone and say, why at this point are you not wanting to spend money? What are your concerns? What are you worried about? Do you understand what your children are worried about? And then actually could speak alone with the adult children and say, well, these are some of your mom or dad's concerns, and what do you believe mom or dad needs to spend money on right now? What are you worried about happening if that doesn't happen? So a mediator would have a choice if it's a very contentious issue of doing that kind of mediation where you're meeting individually and carrying messages back and forth. It's called caucusing and shuttle mediation. And the advantage of that is if feelings are strong, you can find out what people's interests and underlying concerns are and figure out a strategic way to present that to the other person. Or if it's just that the dialogue's never been opened up, a mediator with everybody in the room could start talking about that. Mom, why are you so reluctant to spend money on X? And do you understand why that's important to your children? And have the adult children explain their view. Because one of the tricks of this area is that I'm going to talk about the law in the second half of this presentation, but if the older adult is cognitively capable, if they're capable from a legal perspective, they have the right to decide whether to spend their money or not, but that sure can place the rest of the family in a conundrum if it really doesn't feel like a very safe situation, or if because the older adult isn't spending money, all the care is then falling on the adult children to do at great personal cost. So it can become a very naughty, using the KNOTTY situation, and very tricky and difficult to navigate. And those are a couple of different ways. As a mediator, I try to open that up and talk about what's going on underneath and see if there's a solution everyone can agree to.
Yeah, I think that was very helpful, Joan. One of the questions that has come up is what is the difference between mediation and therapy or counseling?
Sure. I can speak to that fairly well because in my social work before becoming a lawyer, I actually was a counselor when I discovered mediation. And whoever raised the question, there's similarity in that you use those same, I guess you call them micro skills as a mediator or as a counselor to help draw people out and to help get them to talk and so on. But the purpose and the focus is quite different in mediation. Therapy is often aimed at trying to empower people to get them in touch with themselves, to have better understanding, to bring about personal change. And mediation is actually focused on, it's a negotiation, it's a changing the structure. So you're getting people to talk, but it's to talk with a purpose of reaching an agreement about the issue that's in dispute. So the focus wouldn't be so much on just understanding how people feel, but really what then? Okay, so it's very, very important to you. So just to give an example, it's quite understandably important to, I will say, every older adult to maintain independence. And so some older adults might be resistant to even considering an option because it feels like a threat to independence. So a mediator wouldn't stop at helping everyone to understand how everyone feels about that. But the question is, what then? What then? What is a solution, mom or dad, that will allow you to maintain your independence while, whatever the adult children's names are, while you can feel confident that mom and dad are still safe while maintaining their independence. And so, you've identified the two issues. There are, concern about safety and risk and independence. So what's a solution that takes into account mom or dad's need for independence as well as the concerned adult children's desire to feel that mom or dad are safe? So it's a problem-solving process, and in that way it's different. So when I discovered mediation, I quite loved it because I love the interpersonal contact. I love working with people, but I really enjoyed the idea of moving it to a step of helping to find a mutually agreeable solution or plan. So anyway, so that's a bit of how I see the difference between the two.
Yeah, I think that really helped me understand the difference. Maureen has some interesting observations about how nice it would be if mediators were offered through the Elder Advocacy Office and perhaps at rates that were more affordable for folks. And then she kind of gets into some discussion about the terminology of mediator and wondering about the use of the word coach instead. I guess it's semantics, but I think it kind of goes back to the question that you just answered, I think, in some ways.
Well, actually, I think that Maureen is really onto something because this question of what to call this is actually a debate amongst mediators. I happen to belong to, there's an organization called the Association of Conflict Resolution, and every month they sponsor a teleconference for mediators from across North America where we meet and talk about various topics over the phone, just share ideas. And we've actually had more than one session where there's been discussion of what to call this process, because mediation, especially because sometimes this process is used to create a plan before there's conflict, and people think of mediation as there must be a fairly large conflict there, like that's the perception. I know a mediator in Texas who actually calls his business something like peacemaking because for many reasons it fits into the culture of the groups that he works with, but they like the term more than mediation. It is very similar to coaching. Actually, there's an overlap, and especially with elder mediation, what can happen sometimes is some family members will agree to come to mediation and others won't. And in a sense, that can sometimes limit the scope of the plan that you're making because you don't have everyone at the table. And really what you end up with instead is almost a coaching process. The family members who are willing to participate, coaching them on how to, what steps to take with the rest of their family to help move things forward. So I think that Maureen is onto a couple of very good points there.
Mm-hmm. We've got one of the participants saying that unfortunately as soon as he hears lawyer, he thinks conflict and cost. And right. I don't know if you can comment on is there a range in what mediators charge based on their background?
It's an interesting question. Now, when I said that there are more mediators, elder mediators who are lawyers here in BC, that's simply because the field grew slower here than in some other areas. That's not as much the case now as it was, say, 5 years ago. It's just that whereas in, say, the United States, there were mediators that came from all professions, the first mediators here in BC, or more of them were, say, lawyers who started in, the wills area or the estates area. And the person who commented is correct. It can be expensive to pay a lawyer's fee. And yes, there will be a range in fees depending on who the mediator is, what their background is. Some mediators would charge a different fee if it was for a longer mediation, say a daily fee instead of an hourly fee. In some jurisdictions, there are mediators who will charge on a sliding fee. I'm not aware of anyone in BC, but it's always possible. So yeah, there will be a wide range. If you go on the Mediate BC website, some mediators post their fees, and not all of those are work in the elder area, but it would give you an idea of the range of fees that different mediators may charge.
Joan, one question I had was, when you are getting families together, I'm guessing that often not everybody lives in the same city. So how do you accommodate that kind of situation?
Well, fortunately, we have technology these days. So, so it's common for a lot of mediators to use a teleconference, say the phone, say webinar, GoToMeeting, Skype, that type of thing, to bring one person in. Particularly easy if caucusing, meeting with one person, but it actually can be done over the phone as well, and you could bring several parties in. And I've certainly done mediation over the phone and at a distance. I tend to prefer personally, as a personal preference, to mediate with people in person, but that's not always feasible, and particularly in an area like this, where, as you know, people may be all over the place. They may not be local, but it shouldn't prevent a person from going to mediation at all.
Mm-hmm. Yeah, great discussion, everybody. Thanks for your contributions.
Wonderful. Now I'm seeing, I just want to confirm the time here.
Yeah, it's about 7:15, and we did have one question that I think pertains to the next section of your presentation. So other than that, I think we've answered all the questions in the chat box.
Okay, perfect. So why don't I go into the next section, and I'll do the same thing. I think, unless, Janet, if you see something that seems urgent, just feel free to interrupt me. Otherwise, we'll build in some questions at the end, and if in the interim, we'll handle the questions from the second section, and if you think of questions from the first section, then as well, I'm happy to answer more. So
terrific.
Okay, so I'm going to talk a little bit more about elder care decisions and conflicts, and then I'm going to move into some of those tricky and thorny issues. I'm going to particularly focus on two areas, as you'll hear in a second. One is issues where there may be some cognitive difficulties for mom or dad, and another where there will be, where there's either some abuse or allegation that mom or dad are being mistreated, and this can be very tricky. Going back to where I first started thinking about elder mediation, as I mentioned, because of calls coming to the toll-free line at my former job some years ago, the unfortunate thing was that we often had calls from a family member who was concerned, and their belief was that someone was taking advantage of their parent, and perhaps they believed that their parent had, say, some early stage dementia, might not be understanding that they were being taken advantage of, or or something could be happening and they might not be agreeing with their parents' decision to still stay in a situation that was risky. But very often it was because there was a concern that perhaps someone's taking advantage and mom or dad doesn't really understand what to do. And so I'm going to talk a little bit about the law here in BC around those areas. But first, before getting into that, I'm going to spend a little bit more time on elder care decisions and conflicts. So let's give an example here. So mom is 87 years old. She falls at home and her children want her to move into assisted living. She wants to stay at home. Siblings take sides in this dispute, and the family is in conflict. Some family members claim that mom is becoming forgetful, and others argue that no, there's been no change at all. Mom always has been just a little bit scatterbrained, and there's really been no change at all as she's aged. So who decides in this situation if mom is unsafe? Is it mom? Is it the adult children? How does this get resolved? To give another example, dad is 91. He lives in an in-law suite at his son's home. He needs some family assistance, but is mainly independent. His daughter-in-law shops for him and assists him with vacuuming and cleaning. He recently met a young woman, 42, who lives in Florida. He's spending large sums of money traveling to Florida to see her. He recently brought her a sports car. His son believes these decisions show that dad has lost his mind and that he needs to help managing his money. Dad and his son are no longer speaking. The other family members are caught in the middle. So who decides? Well, interesting. I'll just pop in here, I guess. I'll talk about that in a second, because in both these scenarios, there are allegations that the parent may not be capable of making decisions. I will note that that second scenario I mentioned, although I may not have the names correct or the ages correct, I don't know if Dad was 91 and the girlfriend 42, but that's actually based on a case that occurred here in BC called McMullen and McMullen, where the older gentleman had met a younger woman and was buying a sports car and flying to Florida. And his children actually decided to go to court to have him determined to be incapable so they could manage his finances, because they were very concerned about the situation. When it went to court, the court determined that that indeed the father was completely capable and that the court couldn't be involved, and the judge actually made a comment that, you know, the court is here to step in and intervene in situations where someone's not capable, not where someone is not making wise decisions. So that was the McMullen and McMullen case. But of course, it's very, very difficult if you're a family member and you see a parent making decisions that seem unwise, or where it seems like someone actually is taking advantage, because there are many situations like the McMullen case where, you know, Mr. McMullen was certainly capable, but there are cases where somebody isn't. Somebody actually has dementia and isn't able to have accurately assess what's going on, and somebody is taking advantage of them. And that too is very heartbreaking for family members to watch. So, so what we're going to talk about in this section is protection from abuse or harm. When does the government intervene to protect vulnerable adults? Talking a little bit again about that issue I raised briefly in the first half. What if the older adult doesn't want help? And I'll talk a bit about legal capacity. So that's our objective for the second part here. So just mentioning about protection from harm just for a second, sometimes conflict arises because the family caregiver is worried that abuse or neglect, self-neglect is occurring. And so just statistics are very varied as far as how common it is, how common elder abuse is. That's largely because different studies use different methodology and define abuse differently. There was a recent study by the National Initiative for the Care of the Elderly, NICE. They did a nationwide prevalence study, and the figures that they found, or the prevalence for abuse, are what I have listed here on the screen. I would like to note, though, that many believe that elder abuse is actually underreported. And in the case of financial abuse, many experts believe that in a situation where an older adult is taken advantage of, that often the person taking advantage is a family member, although not necessarily the immediate family. It could be extended family as well, and that often the older adult doesn't recognize that someone is manipulating or taking advantage. And to that end, I just want to briefly mention a study that was done a very long time ago that I recently came upon. This is a study by Charmaine Spencer, and it was actually done in 1992 or 1994. I can't remember. It was done through the Simon Fraser Gerontology Research Center, and she interviewed 200 older adults. She actually didn't use the word financial abuse. She talked to them and asked questions about how do you manage your money and about finances. And then as part of the study, she gave them scenarios, and these scenarios were based on criminal code offenses. So in other words, they described, for example, theft by power of attorney. So the scenario was about something that occurred that would meet the definition of theft by power of attorney or fraud. And then she asked the participants questions like, has anything like this happened to you? Or do you know anything? Have you ever had any family members or friends that this has occurred to? And her prevalence rate came out much higher. She found that of participants in the study, that 1 in 12 older adults had been financially abused, actually in amounts of over $20,000. So, so this concern about how to keep an elderly parent who may actually have some cognitive difficulties is a very stressful and difficult area, and there is some reason for concern. So let's talk about what the laws are in this area. First of all, when we talk about harm or about elder abuse, of course, many people categorize this in different ways: physical abuse, emotional abuse, sexual abuse, financial abuse. I'm not going to go into these in detail. I'm sure we're all familiar with this area, and you can refer to my slides and notes as well. So what can the law do if, for example, let's say you discover that your aunt has a new friend who they've just met who's suddenly coming over to the house and being helpful, and you're a little worried about your aunt because it seems like her health's been declining and she's not as sharp as she once was, and suddenly there's this new friend, and next thing you know, the new friend is going to the bank with your aunt, and you're beginning to become suspicious that something is going on. Well, that would be early indicators. So, likely no criminal law offense would have occurred at that point, but I just note that some cases of elder abuse, including financial abuse, may be a crime. For example, obviously with physical assault, but as I mentioned, theft by power of attorney or fraud. There's a number of criminal code offenses that some types of financial abuse fall into, and if you believe a crime has occurred, you can report it to the police. If you're lucky enough to live in New Westminster or Vancouver, there's special police units that focus on the elder abuse area. Studies have shown, though, several studies that older adults commonly do not want to be involved with the police, or even if a family member has taken advantage of them financially, they don't want that type of police involvement. So, you can report it, but I guess I would also suggest that if your older adult family member, friend, that type of thing is completely cognitively capable and doesn't want any police involvement, I believe it's important also to respect their wishes or to step very carefully depending on what the situation is. I want to talk about less known law, which, some of you may be very familiar with, but others not so much. And this applies to British Columbia. So I understand that some of you are from other provinces, so I'll just pause for a minute here and mention the difference in different provinces. In every province, criminal code laws apply equally the same, but every province will also have its own civil law statutes, and in many provinces there is one or more laws that provide protection to vulnerable adults. And how a vulnerable adult is defined will vary depending on the province. And these laws don't necessarily specifically apply only to people above a certain age, but if people above a certain age are vulnerable as defined in those statutes, then they'll be protected. And the degree to which there's a government intervention or the situations in which the government will intervene or criteria will be met so that the government will intervene in a situation of elder abuse will vary according to province. So let me compare just for a second Ontario and British Columbia. In Ontario, if, say, someone lives in a long-term care home and they're a victim of elder abuse, that's something that can be reported and intervened in because the Long-Term Care Act requires persons to report. It mandates reporting of elder abuse. But Ontario doesn't have a abuse and neglect statute that applies to all people living in the province. It applies to people who live in certain situations or, are in certain circumstances. In contrast, Here in British Columbia, we have a law which is embedded in the Adult Guardianship Act. It's in Part 3 of the Adult Guardianship Act, which enables actually our health authorities and our public guardian and trustee to intervene in certain situations where an adult who's deemed vulnerable is being abused or neglected. And the definition of abuse is set out in Section 44 of the Adult Guardianship Act, and basically it applies in a situation where someone is abused or neglected and is unable to seek help and assistance on their own. So that could be they're unable to seek help and assistance because they're physically disabled and unable to access help. It could be because they're locked up or restrained in some way, or most commonly because they're unable to make a decision about the abuse because of a cognitive defect. And where that typically applies to older adults is an older adult who, say, is developing a dementia may not be able to make a decision about what to do in a situation where they're abused or neglected because of cognitive difficulties because of the dementia. So here's the act. Actually, I've written it. I've just described it, but I've written it for you. So as you can see, the Part C is the one that most commonly applies, say, to older adults who are, are developing dementia or have dementia. The trick of this is that it isn't just an older adult who has some cognitive difficulty, but some cognitive difficulty that prevents them from making decisions about the abuse or neglect. So if an older adult is being abused and is unable to seek help and assistance on their own, the matter can be reported to the designated agencies who are required to investigate. Here in BC, the Public Guardian Trustee has designated the 5 health authorities plus Community Living BC as the agencies that respond to abuse under this statute. So they're typically in a field called the designated agencies. If the abuse is financial, then the designated agency will work closely with the Public Guardian Trustee, who has authority to intervene and to protect assets. As I already said, some but not all older adults with dementia are legally incapable, and you meet the criteria in Section 44C. But I do note that, there's a common ageist myth that older adults are forgetful and that it's a part of aging. And as we all know, it isn't a natural part of aging, that dementia is actually an illness or a group of illnesses. And the prevalence rate of developing dementia is higher in older adults, but older adults do not necessarily have dementia. It affects 1 in 5 persons over 65 and 1 in 2 over 85. This issue will impact society increasingly as the population shifts. The statistics in the change in population are here. Now, I just will pop in here that one of the tricky things for a mediator in this area is that often if there's a family conflict, or in some families if there's a conflict over elder care issues, a family member may say, well, mom or dad needs help because I don't think they're able to manage their finances anymore. And certainly in some cases, the older adult may not be capable. In some cases, as I already described with Mr. McMullen, the older adult may just be making choices that might not be wise, and also may be very stressful for the family members, because obviously if Mr. McMullen spends all his money, then the adult children may end up paying for the cost of care and so on. So, that's very stressful. In some cases, I hate to say this, but this is actually the case, given the prevalence of financial abuse. Somebody may allege that an older adult is not capable of managing money or taking care of themselves simply because they want to take over managing the money, and it's a strategy for getting access to assets. So this is a challenging area for the mediator who has to sort out in the situation what's really going on there and, what mom or dad's abilities actually are. So let's talk about capacity from a legal perspective. Often the word is used in the medical field and we're thinking of how someone functions or their capabilities or their abilities, but capacity has a specific meaning legally as well. Now the medical evidence of how well a person can function is very important as evidence to know whether or not they're capable, but it doesn't determine whether the older adult is capable. That's actually a legal test, and I'll talk about that in a second. But, I'd like to note that, there are different degrees. Someone can have, say, early dementia and have the ability to make some decisions, but not others. Someone capability may fluctuate, so they have the ability to make decisions at some points or not others. And for this reason, the legal test for capacity is actually focused on the specific decision at hand. So if you're asking, is the older adult legally capable of making a decision, you're actually talking about, are they legally capable of making this specific decision on this specific topic at this point in time? So when asking a question, is he or she capable of doing X, it's important to consider capable to do what? What is X? So a capable person, and this is, there's slight variations in the legal test or how a court would analyze whether someone's capable, and that's beyond our discussion today, but just to summarize briefly, a legally capable person is someone who understands the context of the decision to be made and understands the consequences of the decision to be made. So for example, if an older adult was appointing someone as a power of attorney, the question is, do they understand the context? Do they understand that this is a power of attorney and what a power of attorney does? And do they understand the consequences of the decision? So do they understand that this will enable someone else to make decisions about their money? So that's essentially the test for capability. And interestingly, in mediation, you could have a situation of, say, you're mediating with a family of, say, adult siblings and an older adult who has, say, early dementia. That older adult may have the capability to make some decisions, but not others. So they might be able to make all their own personal care decisions. They understand everything having to do with personal care, but they can't understand decisions having to do with finances, just to give a very broad kind of definition there. And so in that situation, the mediator would allow would ask for the older adult's views and opinions on the, say, care issues, if that's what the decisions that they could make. But if they, were not capable on finances, the person who, say, had the power of attorney or was authorized to make decisions, the mediator would rely on that person to give input about any financial decisions made in the mediation. So as I said, it's possible to have legal capacity to make one type of decision but not another. And that law, just as an interesting aside, different levels of legal capability are required for different legal decisions. I always kind of laugh because greater capability is actually needed to make a will. That's probably a good thing to have a high standard of understanding to make a will, but there's actually a fairly low standard for having the capability to marry, which may or may not be wise, depending, I suppose, on, the context of that particular decision. According to the law, adults are presumed to be capable, so it's assumed that someone is capable and has the legal right to make their own decisions, unless, there's evidence to show otherwise. And so where that comes into this whole caregiving issue is that at law, an older adult has the right to refuse assistance or help as long as they have the legal capability to make that decision, even in a situation where they're at risk of harm. And this is a really, really difficult conundrum. As I said, it's hard when someone that we care about is at risk of harm. And so I guess would stress why that's why I believe so strongly in the usefulness of mediation in this area, because although an older adult may have the legal right to choose to live at risk, perhaps by sitting down with a mediator and for the family to talk openly together and to work on resolving the issues, a plan can be created where the older adult, the situation the older adult is in can be changed so that there's less risk of harm or of mistreatment. And it's something that, the family can work out and the older adult can choose voluntarily rather than getting locked into a conflict over some of these care issues. So a capable person understands the context of the decision to be made and appreciates the consequence of the decision. It's decision specific. The ability may fluctuate, and I've just to show this graphically, I've shown this on a continuum where a person may have more capability to make decisions or maybe less capable to make decisions. So for the purpose of Section 44 of the Adult Guardianship Act, when it comes to care issues, if, say, an older adult is in a situation where family members believe that they need more care, more protection, a different decision, and the parent says, nope, I would like things to stay as they are. Say if going back to that matter of the aunt who suddenly has a new best friend and you have this sense that this new best friend is taking advantage and trying to get access to the aunt's money. Well, the question really is if the aunt wants to continue being friends or loaning or giving money, well, do they understand that they are at risk of harm, or do they understand the context that there's a risk of harm or that this other person may have access to their assets, and do they understand the consequences, that something bad might happen or that money may get spent or that they may end up being short of money later. If they completely understand this, and they have the legal right to continue or to stay in the situation they're in, or, Section 44 doesn't apply. The government is not going to intervene and to remove them from the situation or to block assets or to do any of those things. But on the other hand, if an older adult is being taken advantage of financially, physically, or in any way, and they are not able to seek help and assistance on their own, then the designated agency and the public guardian trustee can intervene. And I believe that there's numbers for the designated agencies on the public guardian trustee website. If not, you can Google it, but you can access those numbers and make a call and report the situation. And the designated agencies are required to investigate, if they believe the criteria are met. So if they believe that that adult may not be able to seek help and assistance on their own, and there's allegations that they're being abused, they're required to investigate under the statute. So I'm just going to talk briefly about two little scenarios to give just to illustrate this. These are drawn from the health authorities and other organizations working in the elder abuse field commissioned a 2-year research project several years ago, which was published in a document called the Provincial Strategy Document. None of that's that important, other than that there was some really good scenarios and practical tips for this area in that report, and I'm drawing these two scenarios from that particular report. So I'm going to talk about how Section 44 would apply to these two scenarios. So this is Mary. She's 75 years old. She lives in a rural community. She has MS but no cognitive impairments. She's been a victim of domestic abuse and violence. her son takes advantage of her. He has her power of attorney and he misspends her money. She's in this situation where she doesn't have very much control, so she's fairly vulnerable, but she has no cognitive difficulties at all. Let's contrast this with Indira. Indira is 80 years old. She lives in an urban setting in a residential care home. She has very close family and friends. They listen to her values, wishes, and lifestyle. She has comfortable assets, and her assets are held very safely because her family's keeping a close eye on her. So even though she has very low cognitive ability and is probably not legally capable, she's not that vulnerable to abuse. So based on these facts, how does Section 44 apply? So Mary is legally capable. Even though she's being mistreated, she can seek help and assistance on her own. So Section 44 doesn't apply, and if someone was to call the health authorities, the designated agencies in this situation, they couldn't intervene because this doesn't fall into their mandate. Indira is not capable, but she's not being mistreated, so Section 44 obviously doesn't apply either because she's not being abused or neglected. If you change the scenario here, if Mary had a cognitive disability and it appeared that she was significant enough that she might not be legally capable or she couldn't make decisions about the abuse herself, then Section 44 would apply. And if someone called the designated agencies and made a report that they were concerned about Mary, the designated agencies would be required to investigate, and then they have a range of powers to intervene. As I said, if it's financial, they'll involve the public guardian trustee who can freeze assets or take other steps. The designated authorities actually can pursue various court orders and so on to aid to get the person the support and assistance they need to ensure that they are safe. So summing this up, I want to move outside the kind of abuse incapacity and talk more broadly. Where there's a family conflict regarding care of an elder, mediation is a good option for resolving it. In situations where there's conflict and there may also be abuse, it's up to the mediator to ensure that mediation helps to make the older adult safer, not less safe. And if in situations where there actually may be some abuse going on, if one can consider other options such as reporting it to the police, calling a designated agency, and so on, and that's something that a mediator could help with in that situation. And so this brings
and such a good example, but I want to thank you so much, Joan. It's been an excellent presentation. I've really enjoyed it, and I can see from all the comments from all of the attendees that they've hugely benefited as well. If anyone has any final questions,